Speaking on behalf of the state of California, speaking on behalf of the people of the state of California, speaking on behalf of the people of the state of New York, to file a criminal charge, meaning from the date that they say you engaged in DUI, from the date that they are to file it, there's a timeline. Hello, beautiful people. Welcome back. We're all going through our own form of trials, one way or the other. None of us is exempt from that. But you may be surprised to realize that whatever trials you're going through, others are also going through it. I don't know what it is specifically with this time of the year. Around this tax time, there always seems to be a consistency of certain things that occur almost in a cycle. I have noticed that. And for this year, over the past 5 weeks or so, I've had about 7 or 8 different people bring my attention to the same thing that they're all dealing with in their own respective jurisdiction. One of it is the issue of DUI or DWI, driving while intoxicated. All these 7 or 8 different people had this exact situation in different places, whereby something occurred once upon a time, they were never charged for that DUI, and then years later down the line, they now come up with some charges. Now there's a frenzy. There's element of fear, element of shock. Granted, those bringing these charges towards you know very well how the art of war works. War is one thing, the art to it is another. And surprise and the element of shock is one of the ways you win it. And obviously they're putting it to use. The solution that I'm about to mention in this video has been mentioned in other videos independently as its own subject matters. But something tells me most people who later down the line find this channel, they really don't watch those videos. They just come and they just dump the circumstance and scenario on you. With that said, before we start speaking of anything else, which will basically show in details particular to 2 jurisdictions that I find the most common, that many people have been coming in repeated cycles, because obviously it's a culture there. So obviously, since it's a culture, they just do it consistently. Even more obvious is the people there don't know what to do. So what they've been doing as a culture, as tortfeasors, works. What works is repeated. Basic element of business. If it works, no need to fix it. Just keep repeating it. So we'll be going over California and New York. These are the 2 jurisdictions that I've noticed most people deal with these type of circumstances. This man or woman was not the one controlling the vehicle. They were not served a complaint for over 3 years in California. That's the reason why we're showing California in this video, and the other one will be shown as New York. And then they were finally served with a warrant and whatever name, which I redacted that, but they did so in 2023. So 2020 went by, 2021 went by, 2022 went by. Towards the last quarter of 2023 was when they served them a warrant. When they first got out of whatever charges they charged them with in 2019 earlier, because, well, DWI, they charged them somehow. Remember, whenever you were formally detained, arrested, put in custody, they took your picture, they took your fingerprint, all that. You are in the system as a presumption of guilt. Whether or not they used a formal judicial system for the purpose of the safety of the people of state of, in this case, people of state of California, for it to be adjudicated upon whether you're guilty or wrong, does not change the fact that they have the presumption of guilt down. You should have done something back then to remove any possibility of it going into court cases, which is what we speak of when it comes to trust, which is what we speak of when it comes to injunctions. Most people who deal with things like these try to do all these things retroactively. So now we have to go all the way back to the beginning expressing all these things to them. But since 2019, these men and women were charged. But when they were charged, they were told, oh yeah, you had no court date because none was filed. Kept going back and they never had them in the docket. So they moved on with their life. They even got some traffic ticket and they were told, oh no, there were no warrants. Right. It was just sitting there in the residue waiting to be used when they need to cash out municipal bonds or other type of bonds and derivatives. You know how you buy some shoes, you go, man, this shoe costs $80. I anticipate that it will go up in price about $250 next year, so I only really need one. And I know this one shoe is going to last me for 3 years, but I'll just buy two nonetheless because the price of two will be beneficial to me for the price of one in the future. So that when you wear that one shoe out, since it's your favorite shoe, you can have another pair you're going to put on. Here's another example. You change your own vehicle oil. So you don't want to keep going back and forth to the automotive store to purchase vehicle oils again. So you just buy about 5 of them. So you know every 90 days you just change them as you will. Well, in business, people do that also. They charge people and just leave that sitting. When they need it, they bring it up. People and people's lives and the charges attached to people's lives as trials and tribulation that you are not the only one going through are used as resources that can be dug up for municipal entities and their representatives to cash out. They see you as numbers. It's that simple. In case that reality is not clear for some, which it sort of behooves me when people act aloof and surprised. Oh my God, they're doing this. Of course they are. I'm not siding with them. But what, you expect them to show you compassion or friendliness? No, this is warfare. So this man or woman was charged. But since they told him, oh, there's no court case, thank God, my ancestors looked out for me. Oh no, it's coming back to bite you in the ass. The reality is she ought to have done her trust, her non-UCC, and an injunction to stop and kill that from even coming into the public. Most don't do that. And that's just the simple things that people can do without looking at how court works, without looking at how trust works. All the hundreds of videos that's been done in this channel, on YouTube and on Patreon. And because I'm aware many people are new to these things and they usually find solution in a frenzy, I'm taking the time to show this example as a caveat to those who are to come and to those currently experiencing this, and to those somewhere in the middle, the necessity and importance of doing something beforehand, because prevention is better than cure. It might seem like a waste of time and a lot of energy, you doing this, doing that now, but that itself prevents a lot of things that you are not even aware of in the back end, before you get to situations like these ones that I'm showing and explaining. So in their situation, let's say after they got served with a warrant, the court minutes reflect that they had put in not guilty plea in 2022. Meanwhile, they were only served warrant in August 2023 and charged 2019. But the case never really publicly became in an adjudicated status until 2023, but it retroactively reflected guilty plea in 2020 because they were charged, and the assumption is you are guilty. Right. So what they did, they requested for a hearing. We did a video on for a hearing, this video. Now, they're about to start going into what they did, which is one of the reasons I'm making this video. In your situation, since this is the case when it comes to timeline, like they would hit you with statute of limitation, you should hit them with that also. Like they would hit you with the issue of speedy trial, you should do that also. Those are your two solutions, to which 2 particular videos have been done on them, respectively. Speedy trial, and when it comes to statute of limitations, the different forms that comes in, these videos. They requested for a hearing, which of course, by default, anyone who knows what's going on, they'll realize, oh, yeah, you're taking the wrong route. You really don't know what to do, huh? Instead of you demanding for dismissal and moving on constitutional grounds because of lack of due process in form of lack of speedy trial, because you were charged in 2019 and you weren't served 3.5 years later, and lack of due process being substantive, meaning something on the record is inaccurate, which you never did. The constitutional challenge should entertain that also, and should put a notice in form of an affidavit stating that you never entered that plea. And the only reason why the assumption of you entering the plea exists is because you are assumed to be an employee of the United States, aka a United States citizen. You're supposed to put an affidavit contrary to that on the record, which is on the website. Now they said they submitted a constitutional challenge. What exactly they dealt with, entertained within that constitutional challenge, how or if they tailored it to these prerequisites that they mentioned that they know of, whether or not they tailored the constitutional challenge to it, we don't know, but I assume that's not the case. They denied the allegation. We don't know how this was done. And they did a motion to dismiss. We don't know how this was done. He was charged in 2019. The case was open around 2023, but they showed that he pleaded in 2020. This is what I don't like. The fact that they cheat people like this and think they can get away with it. That's why I'm making these videos. That doesn't mean you're not wrong with the way you're doing things. That doesn't mean you trying to take a shortcut is not wrong. And it doesn't mean I'm going and pampering you and not tell you these truths, because that's the main thing preventing you from the solution and the outcome that you desire. So I'll tell you these truths, while also telling the truth as to how they fucked up on their end. For you to be right, you must do things right. It's that simple. You cannot straddle the fence. They denied their motion to constitutional challenge. Prosecutors said they don't know what to do about it. Judge said the federal rules of civil procedure don't apply in state courts. They're right. If you got the constitution things when it comes to rule of civil procedure and criminal, I always let you know the federal is just a uniform version, but you have the state level. I even take 2, 3, up to 5 minutes to show independent state equivalents to let you know the important that, look, they exist in your state also, so use the one in your state, but the principle is the same. It's like you saying, I'm rich, okay? Are you rich relative to those you grew up around, or are you rich relative to accounting methods? It's like you telling someone and they're saying, I know. Do you really know? Or are you just hearing me? Same thing applies with people using templates. They use federal rules of civil procedure, but they're not specific with it when it comes to their state. This is how I know this man or woman. They really haven't studied the things shown in these videos, nor have they used any of the things that's on the website. That's the reason why it's not working. They denied that motion for constitutional challenge. And 2, they denied his constitutional challenge. It's an intervention where you call a third party to certify the constitutionality of the case. And if it's not done, then you move to dismiss based on a lack of constitutionality, particularized to your circumstance that you've listed. And they're now adjudicating it, because that's the job of a prosecutor. The charges filed against you through your biometric data, your fingerprint and your photograph is one. That's just for the municipal bonds to be issued. The charges filed in the public courthouse by the prosecutors, aka the attorneys, are called criminal charges, which is meant to be attached to public at large based on your protection and commerce, to make further fractional reserve banking and kill 2 birds with 1 stone by making you a slave. Serfdom is very real in the 21st century, and it's done in pen and paper. This statute of limitation when it comes to charges is referring to the public adjudication to balance the book of what they've done privately when they took your fingerprint and your mugshot. Again, this statute of limitation refers to the public adjudication, aka prosecutors to file criminal charges, because each of those state codes attached to DUIs, whether it's classified as misdemeanor or felony, has a statute of limitation itself, and that statute of limitation is the maturity date of that bond. It's always a commercial issue. And if the statute of limitation, aka the commercial maturity of that bond, has passed, they cannot adjudicate publicly because it's all tied and linked. We explained that in this video on YouTube. To the man or woman who sent that email, and to all the other people dealing with this situation, have you watched those videos? If you have not, you are cheating yourself. Many people who tell you do a constitutional challenge, move to dismiss, this in commerce, do a DBA, all that, they're not explaining these details to you. They're leaving you half naked, and they're telling you go into a battlefield. They're throwing buzzwords at you. That's the reason why that acting judge told you you have an idea, but you're just not doing it right because you don't quite get it. You're still using someone else's state of mind and someone else's buzzwords to do it. You really don't get it. These videos are here explaining the details to you so you get it. I'm explaining it to you this way in a very relatable layman words, layman conversation type, so you get it. So that when you go out there, you would realize that you don't want others talking to you like this, so that your life will put heat on your ass enough to go out there and fix your own shit by knowing the details, not just the buzzwords involved. As it's always mentioned here, that's what matters the most in everything. The why and how. You know the what, but not the why and how. And at the end of the day, you're using federal rules of civil procedure in state cases. You're not doing statute of limitation in the form of affirmative defense. You just, whatever template you're seeing out there, you're just throwing it out there. Freedom comes with self-responsibility, knowing the subtle substance of these things, such as what we're explaining here. That's what matters the most beyond the intellectual nature of printing paper and sending it. If you don't know the why and how and the spirit behind it, printing the paper and sending it is just a dead piece of tree that you're sending with a bunch of chemicals on it. And that's it. It is lifeless. It is dead. This is the reason why they consider people civil and mortuus. You can write all the things you want on a piece of paper. It is dead if you don't get why and how involved. The spirit of it will never be felt by those touching it. And it would not reflect in the way that you express it. Sure, you did an affirmative defense, but did you express that affirmative defense in form of a statute of limitation, which is exactly what applies to your case? Why? Because the statute of limitation is a time limit imposed on prosecutors to file a criminal charge. The DUI occurred in your situation in 2019. All right. They didn't serve the warrant until 2023. Presumably, they didn't open the case in 2023. 2020, 2021, 2022. Towards the end of 2023, that's about 3.5 years. And you know this fact. You're well aware of this. But somehow, when you did your affirmative defense, did you incorporate statute of limitation in your affirmative defense? Considering that 3.5 years went by since the event, because statute of limitation is imposed on prosecutors to file the charges since the event. Now, just like you have an affirmative defense to show equitable tolling, that statute of limitation should not begin to run or toll until a certain period of time, they also do. Meaning they can say, well, we never really brought the charges until this time because of this, which we'll be going after. And even if that's the case, why did it show on the record that you allegedly entered a plea if truly you did not in 2020? These are the questions you should be implicating into your documents as a reason to dismiss. Bad faith, lack of due process, miscarriage of justice, failure to file within the applicable limit. The complete 44-minute videos on a page for page. Take care. Best of luck.